Hi, everybody. Thank you for joining the second to the last session. We have here, our session this afternoon is legal rights in medical care, executorship, and teen rights to talk privately to the medical team. I'm Katrina Fields. I am on the Transplant Family Board, and I also work at Cincinnati Children's Hospital as a VAD coordinator. And most importantly, I am a mom to a kidney transplant recipient of 6 years. So I am honored to welcome Caleb Lihn, who is an estate planning, elder law, and special needs attorney. Inspired by the experiences of raising his daughter and caring for his ill mother, Caleb is here to share his passion of assisting individuals and families who need help navigating through the complex issues that they face in the world of estate planning, elder law, and special needs planning. So without further ado, I will turn it over to Caleb.
Katrina, thank you so much. I appreciate it. Are you able to see my slides on the screen?
We cannot see them yet.
Okay.
There we go. Something's moving. There.
Okay, perfect. And so, yeah, thank you so much. It's an honor to be here and speak to you all. Like Katrina said, you know, yes, I am an attorney, but also I have a medically complex child who has a congenital heart defect that most of her peers are on a path to transplant. That's one of the big forks in the road they go down. So I am not in your shoes, but we walk similar paths. So I'm happy to be here, and I feel bad because I'm going to go over a lot of stuff today that's deep in terms of we could spend a lot of time talking about any one of these concepts. In fact, I teach a law school class on special needs trust administration, and we spend a whole semester talking just about that. So I'm really just trying to give you high points and issues to spot, things to think about that may apply to your family and your situation. So forgive me for talking quick, and forgive me for going through really a lot of stuff in a short time, but hopefully there's some takeaways here that will be helpful to you in your various journeys. So when we talk about young adulthood, and kind of one of the things I was asked to talk about was that transition from when our children age into adulthood, and there's some legal changes that happen there with becoming an adult. And some of those challenges can include a change in government benefits, a change in care services, a loss without some other action, a loss of the ability to make healthcare decisions for your child, and legal and financial decisions, or participate and influence their education. So those are all things to think about. But before we get down that road, one of the things I was asked to talk about that comes up a lot in your worlds is decision-making before adulthood. So can a minor make their own medical decisions, like regarding a vaccine, regarding birth control, etc.? And I'll give you the typical lawyer answer, and that is, it depends. I've included a link here, and I think these slides will be available, so hopefully they can get out to each of you. But there's a link here, and you can take a picture of it too, that is a nice overview. I think it was updated in January of 23. It has a nice overview of every state's rule or statute or law on minor decision making. The majority of them, the short answer, all kidding aside, is no. A minor typically can't make their own medical decisions. I included a couple notes here. So like District of Columbia, a minor age 11 or older can consent to a vaccine. So in the District of Columbia, the answer to can a minor make their own medical decisions about a vaccine would be yes. In most states, the threshold is 14, and in the vast majority of those, another requirement besides the age is that they be living apart from their parents. So I'm in Arizona. In Arizona, you specifically have to be emancipated or homeless, and not just living apart. A lot of states just say living apart. So you could be living with a relative, and that counts as living apart. So what I would say on this is just, you can go to this link and be aware of your state's law on minor consent, what they consent to as minors in terms of the constellation of their own medical care. And there are some exceptions, like I didn't even know this till I was preparing for this talk, but in Arizona, a minor can consent. There's a specific carve out in the statute that a minor can consent to treatment for venereal disease without any consent from a parent. And if you think about it, there's some solid reasoning behind that. So just take a look at this and then think about it and be aware of what your state is, and if that's an issue to you, and knowing and maybe even educating your child what they can and can't consent to. And then if there's a divorced family, and so the parents are sharing custody and sharing legal decision making, essentially the rule on that is going to flow from the family court order. So if there's a family court order that says the parents, that one parent over the other has, the legal decision making, which would include medical decisions, then that's who's going to be the consenting person. If it's divorced or if it's split, then you're gonna have to try to agree. But ultimately, that's going to come down. That's kind of not in my realm of practice. That's going to fall back into the family law realm. So that would be how that would be sort of decided or played out. So then, as we fast forward and think about making decisions after 18, it's hard because you've made decisions for your child. You've advocated for them. You've looked out for them. You played mama bear, papa bear. And it's going to turning 18 is going to thrust upon you a whole host of challenges. So a doctor's office may not share healthcare information with you all of a sudden. The Division of Developmental Disabilities in your area, the case manager may make decisions without you. A school may no longer, if your kid's still in school, may no longer allow you to participate in IEP meetings. So there's a lot of threshold issues that come up there that we have to think about and plan for. So when we talk about that kind of planning, there's a few possible solutions. So there's powers of attorney, which I'm sure everybody's heard of. We'll talk about a little bit. There's guardianship, conservatorship, which isn't so applicable, limited guardianship, and then supported decision making. And so let's go through those a little bit. I could spend all day on these, but we just don't have that kind of time. So I just want to give you the kind of the meat of the issues. So on a power of attorney, an adult, has the legal capacity typically to sign legal documents referred to as a power of attorney. And essentially what you're doing in a power of attorney, whether it's financial or healthcare, is you're authorizing an agent. It could be a mom and dad or whoever's in your circle of care, that authority to make decisions on your behalf. So your 18-year-old child could sign powers of attorney delegating that authority to you or you and your spouse to make that authority. And like I said, it could be for financial, healthcare, mental health care, educational decisions, all of the above. One limitation to know on a power of attorney, however, well, there's a few, but one big one I put on this slide is that it does not prevent an individual from making a poor or bad decision. So you know your child better than anybody. And I have a child who's very impulsive and does not make good decisions. And so fortunately, she's not an adult yet, but when she is an adult, this is something that I'm going to have to grapple with because I don't know that she will avoid poor or bad decisions as an adult. And a power of attorney, even though she delegates that ability to me to help her with decisions, it does nothing to stop her from making bad decisions on her own. So the pros to a power of attorney and kind of creating that delegation is it empowers an individual. It's cheap to put together, comparatively speaking, and they're easy to obtain. You can even, a lot of states have official state sanctioned forms you can get online. There's all kinds of sort of generic forms you can get online. And of course, you can go to an attorney and have them put together. And they're very quick to put together and easy to change. You can just do a new power of attorney and it revokes the old one. The cons are individuals can revoke it. So just as easy it is to put a power of attorney together, it's that easy to revoke it. You just say, I don't want this anymore and put it in writing. There's also a presumption that individuals can still make their own decisions. So in contrast to a guardianship, just because you have a power of attorney, that doesn't flip that threshold. So it may not get you a lot in terms of helping with decision making or information gathering. And then it doesn't prevent an individual from making contracts of their own, marriages, credit card, purchase agreements, all those things they can still do, and they're presumed valid, even though they have a power of attorney. Then kind of going up the scale, there's a guardianship, which most of you kind of walking in the path that you have probably heard of that concept. And essentially it's a court process where you have to litigate or convince the court that the person you're seeking the guardianship over is incapacitated and unable to make their own decisions regarding their own well-being or their finances. And that protected adult's right to make their own choices is taken away. When you have a guardianship, technically you're placed over you, you're losing some liberties and some rights. And that's why we don't get to go too deep today into the process, the legal process of a guardianship. But as a preview, anybody who a guardianship is sought over always gets their own attorney appointed for them to make sure their rights are being advocated for. And then what happens is the guardian makes decisions for that adult, just like a parent does for a minor child. That's essentially the legal analogy. With just like everything in life, there's pros and cons, and guardianship's no different. It's well recognized by doctors, DDDs, schools, kind of all the institutions out there, et cetera. There's one annual report in most jurisdictions that have to be filed every year with the court. It's very easy to do. It's a simple form. There's not a lot of ongoing responsibilities. And it changes the legal presumptions regarding an individual's actions. So they're not as free to go contract or make a purchase or get married. There's a limitation on that, and that kind of goes with that loss of liberties or rights. The cons are, of course, with all this stuff being taken away, it's going to feel overly restrictive, especially for high functioning individuals. In the last year, I've had 3 different clients that have come to me where we've had to take a guardianship down. We've had to terminate it. And the reason being, coincidentally, all 3 were referred by school. One was a teacher and 2 were like resource officers. And they all 3 were told when their child was 17, like, oh, you've got to go get a guardianship. Like and in all of those cases, the children really didn't rise to the level of needing guardianship. And so you lose the right to drive, you lose the right to vote. And for a lot of kids, they can drive, they can vote, and they want to do those things. And so this was a case, or these 3 cases, where they were kind of pushed into guardianship and didn't get the proper solutions or other, kind of alternatives. So hopefully you use this as some, just to kind of vet out what's best for your family if you have to go down this road. And then, of course, because the court is involved, it's going to be an expensive and stressful process. Now, a lesser alternative to guardianship is what we call limited guardianship, where you can still get the court to authorize certain types of restrictions and consents, but the right to vote, the right to drive, the right to marry, to engage in marriage, or other things can be carved in so those aren't taken away. So we're doing more of these for especially kids or adults that just don't rise to the level of needing a full guardianship, because the least restrictive thing we can do is always better. Just like, again, the pros and cons of a limited guardianship are similar to a guardianship in terms of the pros. It empowers the individual. It's a little lesser restrictive. It preserves that right to drive or vote. It grants authority that medical providers and other agencies still acknowledge, so it has that value. And it allows for a court case to be open in the event of an emergent need to change. So you kind of already have the case pending. And if the circumstances are such that, hey, this needs to be escalated to a more restrictive or a full guardianship, you have an easier way in to do that. The cons are it still requires all the due process protections. You have to go through the court process just the same. So it's typically the same fees and costs, and you still have that annual reporting requirement. Another option that's kind of becoming more popular is supportive decision-making, where basically it's more of a collaborative process where the person who the decisions are being made for is collaborating with people, the guardian or others. Instead of having a guardian, they're collaborating with other family members or a network of people that have been put together for supportive decision-making. Of course, the pros to this are you're still getting that empowerment, but there's some flexibility, autonomy, and increased independence with it. The cons are it's not approved in most states yet. It's not a true alternative to guardianship. It's more of like a wish right now. And so doctors, DDD, schools, et cetera, they may not validate it or even respect the contract. And it doesn't prevent individuals from contracting, so they can still on their own make bad decisions. So that's kind of what I wanted to hit on in the guardianship piece. Again, I could spend hours talking about that. The other thing that I thought was relevant to mention to everybody is the concept of special needs trust. And really what that is the assets in a properly drafted special needs trust. And I know that's not the best language. Special needs is kind of an unfavored phrase for many, and I don't disagree, but it's still sort of a legal term of art. So even though it's outdated in the real world, it's still a legal term, so we still use it. Sometimes we refer to it as a supplemental care or a supplemental needs trust. Those are just synonyms, so it all means the same thing. But assets that are put in a properly drafted supplemental needs trust are not counted. They're ignored for determining financial eligibility for SSI and Medicaid. So a lot of people, they can't get SSI when they're minors because their parents' income is deemed to them and it counts, so they're not eligible. But once they hit 18, all of a sudden this world of opportunities to get on SSI open up. Not that it's an opportunity, but sort of that option opens up, and the trust or special needs trust becomes can become important when someone's on either Medicaid in your respective state or on SSI. So just to go over a few things in a special needs trust setting, the person who is the beneficiary of the trust is the person with the disability or the limitation, and they cannot be the trustee. The trustee can be a whole number of people, but that trustee has sole discretion as to the time, the amounts, and the purpose of any distribution. A fatal flaw in a properly put together special needs trust is if the beneficiary has individual access to the funds. They cannot get the funds themselves, or it ruins the structure or the viability of the special needs trust. And so in a way, or quite literally, a special needs trust by its nature, what it's intended for and how it has to be put together, means a loss of control over the funds by a disabled beneficiary, which is sort of an unfortunate, necessary evil when we're trying to put assets in someone's name, but also avoiding ruining or affecting their eligibility for benefits. So the overall goal with special needs trust is to achieve as much independence as possible for that disabled beneficiary. The ideal thing would be, the scenario would be that the beneficiary becomes productive, earns a wage, and they don't need public benefits, but they still have that protection. So where does money come from when you're setting up a special needs trust? There's a whole host of sources, and there's a couple different special needs trusts that I just want to quickly mention because there's some big differences. One is a first party special needs trust, and this is where the money belongs to the special needs beneficiary. So it could be from a personal injury settlement, from a car accident or a medical malpractice suit or something like that. There could be retro pay from some back entitlement or benefit, or it could be an inheritance from grandparents or parents or other family members. Any of those sources where the money is there for the beneficiary has to go in a first party special needs trust. And the biggest thing that in the time we have together today that I want to emphasize about a first party special needs trust is that it requires a payback provision in it. So when that beneficiary, hopefully way into the future, passes away, the state Medicaid agency gets first bite at the money left in the trust to reimburse themselves for any benefits paid to the beneficiary. Also, during the beneficiary's life, there's a lot more restrictions on distributions, and you have to provide accounting. So it's just a lot of onerous requirements and hoops you have to jump through with the first party trust. And then, of course, like I said, the big downfall is the payback provision to the state Medicaid agency. So we encourage people when they're planning ahead to try to create a third party supplemental needs trust. And that's money funded with assets of someone other than the disabled beneficiary or their spouse. So think the money's coming from a third party. And the huge value in the third party trust is it doesn't have that payback requirement. You don't have to provide accountings to the Medicaid agency in your state if you're on those benefits. It's just a lot less onerous. So they're also very simple to draft, or much simpler to draft and administer than a first party supplemental needs trust. So it makes sense, I think, for every parent of a medically complex child to at least have what's called a contingent supplemental needs trust or special needs trust in their planning. And you can do that through a will, or a revocable living trust that you and your spouse or you individually put together, and you can build in that third-party special needs trust into your planning. And then whatever assets you hopefully way into the future leave your child, they can have them if necessary through the third-party supplemental needs trust, and they avoid all those issues. Ideally, they're not on any government benefits. The special needs trust doesn't have to turn on, and that's not an issue. But just as we plan and look ahead, and we don't always know the future, I always counsel families of medically complex children to think about this and at least consider building it into their plan. So, and I kind of touched on this, but for distributions, that is money that's coming from the trust to be spent on services or purchase things. And the first party, and I kind of touched on some of these distributions, are limited by state statute. There's strict reporting requirements to your Medicaid. You have to prepare a budget. Can only be used for the beneficiary of the trust, and everything must be disclosed to Social Security Administration and Medicaid. Whereas if we switch over to the third party trust, distributions can be made for anything that benefits the beneficiary. So you can set it up for multiple disabled beneficiaries. Some families have, the challenge of having multiple kids with disabilities in their family, and so they can, they kind of consolidate this. And it does have to be reported to Social Security and Medicaid, but only when it's funded. So if you've set up something in your estate plan that when you pass away, and hopefully decades and decades and decades from now, and money may filter to your child through a third-party supplemental needs trust, that would be when it has to get reported. Because right now it would just be kind of laying dormant, and there's no liability or duty to present that, disclose the trust or that information. And of course, every special needs trust has to have a trustee. Generally, on a first party trust, it's generally the parents. Sometimes it can be, you can hire a professional to do it. On a third party trust, it's never the parents, because remember, usually that's built into your plan, so it doesn't really kick in until you're deceased, so you name a successor trustee who would be in charge of that. You can also, not to complicate things, but you can also create what's called a standalone third-party special needs trust now. So let's say you want to create your own plan and you wanted to have that standalone trust now that you can maybe put money into for the beneficiary. That can be done too, and you can fund it at any time. Like we had a young gentleman with Down syndrome. He was 8, his grandma died, and left him some life insurance money. So we wanted to kind of put some structure in place where that money could go into the third-party trust now and preserve his benefits. So if there's a need to have money to the beneficiary now, there's flexibility to do that. Some important points here. Most of these I've kind of gone over, and in the interest of time, again, we'll make these slides available. Some additional reporting requirements in special needs trust. And what I'd say is all of this, and I feel super guilty because I've just compressed months of presentation material to you in like 30 minutes. So don't be overwhelmed. A lot of folks have traveled this part of this journey, this legal aspect before you. There's always resources for help. You just, one foot in front of the other, one step at a time, as you've all been doing and advocating for your children anyway. And also just don't believe everything you hear. There's a lot of myths out there about this stuff. So if you're getting it from a non-lawyer, take it with a grain of salt. And then I've made, on this last slide, I've made my contact information available. So if anybody has any questions, the one big caveat I'll say is that I'm licensed to practice only in Arizona. So I am really technically only available to answer Arizona related questions, legal questions. But if you're in another state, I am well connected with attorneys all over the country. And so I can always refer you to someone who does what I do in your state. There's a chance that I know them, or at least can find people through different membership groups. And I think I see some chat. So let me.
Yeah, I think we have a couple questions. I think we can go over for a few minutes. If you don't mind, I'll read them out, and if you don't mind to answer. I'm going to combine the first two questions because I think they're pretty similar. How do I decide which one of these I should put in place for my transplanted child who is turning 18 soon? And then what kind of documents are necessary to be able to help assist in that process?
Yeah, and those are good questions. And I don't have an easy answer for the first one about how do you decide. I think the advice I typically give people is, you know your child better than anyone. And the policy that we should have for our own children and also for that the court has is finding the least restrictive method available. So thinking like what's the least, so our powers of attorney, that's where I would start. Would they be helpful? If your child is very, well behaved and very, not prone to impulse issues and is cooperative with you and takes your advice, you have a good relationship, powers of attorney may be just fine. And you may not have to go to any higher level. Where I would start to think about accelerating the level of intervention for decision making would be if some of those things I just mentioned, if you've got a child who's not super compliant, has a little bit of impulse controls, or if they don't have the ability, if maybe there's some cognitive issues or learning, severe learning disabilities that may affect that, then I would start looking at maybe escalating up to a limited conservatorship or higher. And then of course in your state looking to see if supportive decision making is available. That is a kind of compromise approach between the two. That's what I would say is it's hard that there's no easy, quick button you can push and have the answer pop out because there's so many variables and family dynamics that play into that. Then there's a question about, hopefully that helps. There's a question about how can I find an attorney to help me set up a special needs trust for my son? Are all lawyers familiar with it? And the second part of that is absolutely not. I had somebody come to my office a couple weeks ago who has one child left. He's intellectually disabled. He's an adult, lives in a group home. Her other son passed away. Her husband passed away. She met with an attorney in our town, like a suburb of our town, who told her to write that son out. It's her only living member of her nuclear family. And he said, write them out, leave the money to a more distant family member and ask them to take care of them. So I begged and pleaded with her. She came into my office and I begged and pleaded with her almost literally to not do that. Let me help you change it. We can put it in the special needs trust for your son so that his benefits that are paying his care don't get taken away from him. He doesn't lose that eligibility, but the money's still in his name. And she wouldn't do it. And I never heard from her again. So there's an organization called, I'm on the board of directors for an organization called the National Academy of Elder Law Attorneys. And the website the acronym is NAELA or NAELA. I think it's NAELA.org is the website. There's a method on there to be able to search for attorneys. And most attorneys in NAELA are familiar with special needs trusts. The other option is I have my contact info here. If you tell me where you live, I can try to help pair you up with someone that's I either know is trustworthy or is a member of trustworthy organizations. But definitely do your vetting and do your homework when setting up a supplemental needs trust. I had one that I saw the other day from an attorney in my jurisdiction, and I went through it really quickly with you guys, but there, in third-party trust, I talked about how there's not that payback provision. Well, the estate planning attorney who doesn't do elder law or special needs planning drafted a trust, drafted a testamentary, means it was built into the parent's trust, third-party trust for their child. Well, that attorney wrote into it a payback provision. So what that means is when that child passes away, the trust has to be followed. So the government is going to get money from their child's estate, which it was not entitled to legally. So there was a mistake made by that attorney. So just be very careful in your vetting and getting to the right person for that, and don't just have any estate planning attorney do it if they don't have experience in special needs planning. And then the last question that I see for now is there any special information that I need to put in a will if something happens to me and my husband? So yes, if your child's a minor, you want to make sure there's guardian provisions, who you're nominating to take care of your child if God forbid something happens to you while your child or children are still minors. And that goes for any child, not just children who've had transplants or have other medical complexities. That's any minor. And then if you have some thought that your child may or will be eligible for public benefits from a medical perspective when they're an adult, I would really think about making sure you build in provisions for a third-party special needs trust. So your children or that child inherits funds into that trust, and they still earmarked for them, but we're protecting the eligibility for their public benefits. There's a lot of other design issues that go into a will and trust, but I think for the purposes or the context of this discussion, that's the big one that I would think about. But make sure that you, the advice I guess I would give is to, especially in the shoes that you're in, I would, and of course I'm biased, but I would recommend talking to an attorney about doing a will or a trust versus doing it online or trying to find your own form. That more often than not causes more problems than it's intended to solve. So I guess that would be my advice there. And again, hopefully this was helpful. A lot of it is just me planting a bunch of seeds, and life is going to water them for you, and hopefully they sprout into some helpful information. Because I do feel genuinely bad that I wasn't able to go deeper into some of these things, but my email's there. If you have any questions, please feel free to reach out, and thank you everybody for your time. And I think we only have one session left, so I will get out of here so we don't go in for any further over, and you all can get on with the rest of the conference and your weekend. So thanks everybody, appreciate it.
Thank you, Caleb. It was great information. You can join the next session. Thank you.